Ms. James, can you state your name for the record?
Amanda James.
Thank you.
Your Honor, this is the time set for a bond hearing. Ms. James, as you recall last week, Ms. James was ordered to go to community corrections to test. She did go to community corrections to test. However, she does admit that she did not go straight there. She had to go home first. She went home to get the money to test, and then her mom wanted to stop at Burger King because she was hungry, so they stopped at Burger King. Then they did go to community corrections to test, but by that point, the no bond order was already in, so she was arrested from there.
Oh yeah, I remember. Did we didn't get a test, did we? It was positive, right? Yeah. Okay, so I told her to go to community corrections.
And she did.
She's here on campus. She left the building, and I remember her walking out. She said, "I'm going over." We sent another person slightly after her who got over there, tested, came back. We still hadn't heard from Miss James.
Ms. James indicated that her mom is here and does have the receipt of her going to community corrections the same day.
Oh yeah, I know, but it was like she was supposed to go there and come back.
Yeah. Ms. James indicated that she did not, at the time that she was here today, or last week, she did not have the money to test, so she had to go home first to get the money, and then had to go to Burger King.
Where does she live?
1282 Medford Drive, Huron Heights.
So in this county.
Yes.
So when does it 4 hours or
Your Honor,
hours to go home, come back,
3 hours.
and then do that? And I don't know where the Burger King comes in.
It was not 3 hours, Your Honor. I was going 45 minutes.
Yeah.
I have my test.
Tell me that.
Please,
Because we called over.
she said she called you when I got there, and I sat for like.
I know. She did.
Oh,
But she did get over in test.
She did come. Yeah.
Yeah. Then she left.
I did.
Then she, what, Your Honor? I apologize.
Then she left. She didn't come back over.
They arrested me there.
Yeah, I know. Why? Because we had
Said
this
you put a
warrant.
warrant out. Yeah.
Yeah. And she tested positive for cocaine.
As I said, I possibly would. That was why you tested. That's why you said.
That is not what she said.
Your Honor, I told my probation officer that there was.
Oh my.
You recall.
Not what she said. Told me.
Your
Your Honor, I've
Not talk. I'd turn around like that. I'm done. I'm done. Her bond remains denied. How much time do you want to put it over? I'm not playing games. I am not playing.
I apologize.
Think I am. If you're going to turn around and start smiling and doing all that, this is not a game.
I was just
Bond denied. I'll set it over to July 2nd.
You're not even giving my information, Barker.
Keep talking. You want your case now, Bellinger? Courthouse case, People versus Nicholas Dragos.
Positive people. I'm going to go on behalf of Mr. Draco.
Did you want to say anything or no? What were you going to do?
I was waiting for your.
You can stare at that screen all day. That's not going to happen.
I was waiting on your cue, Your Honor.
You were waiting on my cue?
Yeah, I thought.
What?
Usually you say, "What are we doing?" But I didn't know if that was.
Oh, okay. All right. Okay. So you need a cue.
Well,
all right.
we can. I didn't want to interrupt you.
What are we doing?
We were going to request an adjournment.
We're going to be the same thing because your client's not here.
Right.
Yeah.
We were just going to mention there's an intensive amount of discovery, but he's not here. So I guess my request for an adjournment might be irrelevant.
I will say,
You can make the request.
I will say,
Nick, why are you trying to save him?
because he will save me in the past, Your Honor. Public Defender Nick Bukovich on behalf of Mr. Dracos. I will say Ms. Gaines and I had a very intensive conversation with him yesterday about this matter. So I am confused about his failure to appear today. So I would ask the court to consider an adjournment. This is a case of a very intensive amount of discovery, over 954 pieces of media on Axon to review. So I would ask the court.
You're requesting an adjournment?
Yes.
He said it was irrelevant.
My mistake, Your Honor.
For the record, I would be requesting an adjournment.
Really wouldn't matter. I'm gonna issue a bench warrant. People's requested bench warrant, bond 10,000 cash surety. Warrant will issue immediately.
Thank you, Your Honor.
I'll remember next time. Give him the cue. Court calls case versus Daniel Keener.
Is that on behalf of the people, Your Honor?
Assistant Public Defender Davi Lebo for Mr. Keener. Mr. Keener, can you state your name, sir?
Daniel Keener. Thank you.
And Your Honor, we just received some additional discovery on this matter towards the end of the day yesterday. I'd be asking for a brief adjournment to review that and also would like to address bond.
PC will be adjourned July 2nd, 2026, 9 a.m. As to bond.
Thank you, Your Honor. With regard to bond, I did have a chance to review the calls, and it is my understanding that the calls do relate solely to Mr. Keener getting his property back and having his brother pick up that property. He understands now the proper way to do that was to call the police, ask the police to arrive there first, and only obtain his property with the police present for a civil standby. He now understands this. He knows the seriousness of no contact order. He knows it violates the court to reinstate his previous bond.
Respond.
Your Honor, I leave this in the discretion part. I do want to know that I understand the calls, but I also would like to know that the defendant was not very honest with the court about what the contents of those calls were. And then one of those, or two of those calls, were one was completed to the victim, her number, after he was told not to have contact with her. While it was a short call, I do have concerns that he called her after he was told not to call, and then also called someone else to get in contact with the victim, identifying her by name. So I do have concerns, and I know he was remanded last week by the court. If he is to be released, I would ask him to be on home confinement, because given his bond violations in custody, I would have concerns about bond violation out of custody. But I'm going to
Tell you no contact. Right? And I don't know, and I'm unclear that his reasoning for why he says he's contacting, I don't buy it. I mean, I think it's clear. Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Court calls case people versus Lance Ford.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Ford. Would you please state your name for the record?
Lance Ford. Thank you.
Your Honor, we are continuing negotiations for this matter and would ask for an adjournment.
Without objection, July 9th, 2026, 9 a.m.
Thank you.
Thank you. Court calls case versus Crystal Lewis.
Assistant Public Defender Zach Vinny with on behalf of Ms. Lewis, who approaches. Lewis, can you please state your name?
Crystal Lewis.
Your Honor, we're seeking an adjournment for the negotiation. Well, and then I would ask to be heard on bond as well.
Matter will be adjourned July 2nd, 2026, 9 a.m. Esteban.
Esteban, Your Honor. So Ms. Lewis is currently on a $10,000 10% bond, which is not a bond that she can post. She does have a stable place to live. She lives locally in Ypsilanti. She does also provide home health care for her long partner's mom, Your Honor, as well. She on June 11th, her long-term partner had a serious heart surgery, and she has been unable to see him or check in with him or see how he's doing or help him out. She has two daughters at home, an 11-year-old and a 19-year-old. Wait, is your 11-year-old a daughter or son?
Son.
Oh, sorry. I apologize, Your Honor. An 11-year-old son and a 19-year-old daughter. She will wear a tether if necessary. She will drug test if necessary. She'll do what she has to do. So she is asking for consideration of a personal recognizance bond so that she can, be out and help support her family. And then also, lastly, Your Honor, it is her birthday next week. She'll be turning 49 years old, and she would prefer to spend that with her loved ones.
I hear they have good cake at the jail. Response from the people?
Your Honor, I see that she has a benefit warrant out of the 44th Circuit Court of Powell. I also see that to appear for a motion to carry.
A motion hearing?
That's what my notes said. Failure to appear for a month. If
What's the bench warrant out of how?
I can have one moment.
Yes.
I also see consumption for you.
And does it give a bond?
Bond.
So it would be useless for me to release her because she'd be going to Howell.
But if you were his chair, you'd be going to all anyway. So you'd still.
Motion for bond reduction denied. Bond will continue.
Your Honor.
Yeah. Court does call the case of the people versus Stefan Wainwright.
The guy on the table, Your Honor.
Assistant Public Defender Duffy, Lebo form, Mr. Wainwright.
Mr. Wainwright?
Yeah, they're going to get the keys to open this food slot.
Okay, thank you, sir.
Your Honor, we do still have some competency concerns. We're going to be seeking independent evaluation. We have begun reaching out to experts for that purpose. We're hoping to find one who can do it a little bit sooner than the date we were given.
Oh, do what?
An independent evaluation, Your Honor.
So, say that again, Mr. Lebo. You're trying to get the independent evaluation.
Yes, Your Honor.
You're trying to do it sooner?
So we have reached out to one expert who could potentially do it. He's given us a day of after Labor Day. We're hoping to find someone who can do it sooner than that.
So I'm trying to get released. So if you can do a personal recognizance, we can speed this process up so you can stop bullshitting yourself. So now that you understand that, if you don't release me on a personal recognizance, there's really nothing much to talk about at this point. So it's your decision.
Alrighty then.
Because he's not my attorney. I'll pay for that. I have plenty currency. That's not a problem. But if you guys would like to meet in person, be much better. So I actually have a meeting to go to. I'm a little busy. So let me know. They'll let me know up front. What's your name? Samson? Okay, let me know. And then once you do that, we can meet in person. I have a couple clients that I have to take care of right now.
I'll meet person with anybody. I don't mind. All right.
He was in person yesterday.
Dependent.
Yes, Your Honor.
Yeah, I think so. This was set, his competency, I adjourned his competency hearing to the 18th.
Yes,
You need that adjourned out because you're trying to get the independent.
exactly, Your Honor. Thank you.
All right. Give me a date in August. Set it now. I'll adjourn it out to August 6th, 2026, 9 a.m. Bond at this point will there we go. Thank you. Thank you, sir. What? No, don't. I'm Samson. Yep. No. Court calls the case. People versus Kalani Franklin.
Morning, Your Honor. Raymond Cook for the people.
And good morning, Your Honor. Assistant Public Defenders and Advocate at Ruby. On behalf of Ms. Kalani Franklin Coaching. Kalani, state your name for the record.
Kalani Franklin. You're okay.
Kind of the court.
I have a plea form in front of me. The form indicates that. Okay, I guess the added count too is retail fraud third.
Third degree, yes, Your Honor.
All right, the 93-day. Upon her successful plea to that charge, count one would be dismissed. There is an agreement, or prosecutor will recommend sentence under HIDA.
Yes.
That's the court's full understanding.
That's correct, Your Honor.
Yes. And Ms. Franklin is prepared to enter that.
All right, may I have her sworn?
You telling me swearing if I'm about to give the whole truth, nothing but the truth.
Can counsel approach, please? A brief bench conference in this case. And may I have her sworn?
Do you help me swear and affirm that the testimony you're about to give you will achieve nothing but the truth, so help me God?
Yes.
State your name for the record.
Kalani Franklin.
Franklin, is this court's understanding that you're going to plead charge of retail fraud in the third degree? Is that correct?
Yes, Your Honor.
That's a misdemeanor punishable by up to 93 days in jail, a $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. That's greater than $500. That becomes the maximum fine. You understand that?
Yes.
Right. Still wish to plead guilty?
Yes, Your Honor.
To that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct?
Yes, Your Honor.
Question regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights, which are part of the trial. You understand that by pleading guilty, you'll bring up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you bring up your right to appeal outright.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's on the record to get you to plead?
No.
Anybody threaten or coerce you?
No.
You're doing this voluntarily,
Yes, I am.
of your own free will,
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense? Finish life. Oh, anyway. On the date of December 22nd, better, 2025, at the location of 1254 Horse Road, Ypsilanti Township, Washtenaw County, State of Michigan. What'd you do at Pet City Pets that makes you think that you're guilty?
I took a puppy.
Store was open to the public at the time.
Yes, Your Honor.
You didn't have anybody's permission to take that puppy, did you?
No.
And this is the puppy they had offered for sale.
No.
Why'd you take the puppy?
I wanted to replace my daughter's puppy that had recently got stolen.
Okay.
And this was 3 days before Christmas. How old's your daughter?
3.
At the time, was she 2? Okay. Ma'am, I do have to advise you, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from people?
None from defense, Your Honor.
Have I complied with the court rule?
Yes, Your Honor.
Second, really?
Yes, Judge, we are satisfied.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be before me on
July 22nd at 9 a.m.
July 22nd, 2026, 9 a.m. Bond will continue. And Ms. Wyman, could you? This be. All right. You'll be before me. You can stop down at my probation department right down the hallway on the left-hand side. So we'll get it started, okay?
Okay. Thank you.
You're welcome, man.
Thank you, Your Honor.
Court calls the case, People versus Merrick Lincecum.
There.
I know it. And right here. Assistant Public Defender Chinazi Carey, I can rule, Your Honor, on behalf of Merrick Lincecum. Merrick, state your record.
Mayor Clayton Everett, let's go. Good morning, Your Honor. Good morning, sir. I have before me a plea form that indicates the defendant will be pleading no contest to an added count 3 of retail fraud, second degree, the 1-year offense. Upon his successful plea to that charge, counts 1 and 2 would be dismissed. Defendant agrees to pay full restitution at the time of sentencing. That's the court's full understanding.
That is correct, Your Honor. So you understand?
Yes. May I have him sworn?
Raise your right hand. Solemnly swear and affirm that the testimony you're about to give to the court is the truth, the whole truth, and nothing but the truth to help you out.
Yes, sir.
Now state your name for the record.
Eric Clayton Everett, let's go. Sir, it is this court's understanding that you're going to be pleading no contest to the charge of retail fraud, second degree. That is a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that? Sure. You also understand, do you understand what a no contest plea is?
Yes.
2 things about it I have to make sure that you understand. The first is that it means that you're not further desirous or wanting to contest this charge. You understand that? The second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? Sure. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court. I'm sorry. Basis for the no contest plea?
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead? No contest. Now, you understand that by pleading no contest, you'll not have a trial of any kind. Sure. Signed in advice of rights form, is that correct? Any question regarding those rights? No, Your Honor. Please look at paragraph 5 on the podium. Those are your rights which are part of a trial. And by pleading no contest, you're giving up those rights as well as all the rights on that form. Understand. Understand you're giving up your right to appeal of right. Understand. Are you on probation or parole? Yes. You're on probation or parole at the time of this?
No, this is from 2023, I believe, right?
Yes. But
I was not. I was on probation a little bit after, but
okay, but not at the time. All right, thanks.
Sorry, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Did anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
No.
All right. The court has been handed and has reviewed Washington County Sheriff's Office report for their case number 2353023. Any objection to the court reviewing that report?
None from defense, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, I understand.
All right. Counsel, you're aware of any other promises, threats, or other inducements which have led to this plea?
None, Judge.
And have I complied with the court rule?
Defense is satisfied.
Court will accept a no contest plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing will be
July 6th at 9 a.m.
July 6, 2026, 9 a.m. before Judge Freshour. Bond continued. Thank you.
Oh, here, Don continues on.
Court calls the case of People versus Robin Hardy.
That's the balance of people.
Good morning, Your Honor. Ashley Hannibal for Robin Hardy, requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Stephanie Cannon.
Where's Ken? Are you paying attention? Thanks. Up here, right? You're still analyzed. Permission to practice is granted.
All right. We're just requesting an adjournment today. I'm just requesting an adjournment today for plea negotiation.
Do you hear? Ms. Hardy?
Yes, I'm here. I'm trying to get the camera to work.
Okay. Have my Cannon's cases.
Okay.
Okay, there you are. State your name.
Robin Hardy.
All right. You're requesting an adjournment.
Yes, Your Honor.
Probable cause conference will be adjourned July 9th, 2020.
Your Honor.
Thank you, Your Honor.
Bond continued.
Thank you.
Court calls the cases of the people versus Michael Moore.
Your Honor, Raymond Cook for the people.
Billy Gaines, Assistant Public Defender, with and on behalf of Mr. Moore.
On all six.
Yes.
Please state your name.
Michael Moore.
Your Honor, we are in the process of negotiations. We just recently received the mitigation letter from, as in this week, received the mitigation letter for us to present to the prosecutor. So we're asking for a short adjournment, maybe 2 weeks, so that we can continue negotiations. And we'd also like to address bond for one of the cases, Your Honor. For all of the cases except for 26 F5-5051, Mr. Moore has a bond of $1,010%. We're asking for a $1,010% bond on that matter as well. If the court would permit that bond, Mr. Moore is stating that he believes he would be able to post all of the bonds and get himself into a substance abuse treatment program. That we have been working diligently to get him in that. There's already a release to treatment on all of the cases. We are working to try to get his holds in Dearborn cleared up. He was able to get one. There's one more that we're still working on that has been a bit more challenging, but he would be able to go to treatment. Your Honor was to do that.
I'll adjourn all of these to July 2nd. Do the people have anything they want to say regarding bond?
Maybe you approach, because I have something that I think addresses both the adjournment as well as the bond.
All right. The record should reflect there's been a brief bench conference. Motion for bond reduction will be denied in that case. Court will continue the bond as set. I will adjourn all of these to the 2nd. 9 a.m. Thank you.
All right, thank you.
Court calls case people versus Dean Hodder.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Hodder, Your Honor.
Not sure it's gonna go.
He was what?
Well, it's just a courtroom, I just saw him. Your Honor, may we pass this matter? Perhaps he's in the restroom. I mean, he was in here.
Over at community.
He was here, yeah,
Sure.
long beard, yeah.
So if he doesn't show up, you can go into custody? Yeah, okay.
Yeah.
I'll pass it. It's probably Bellinger. I'll pass it. What are they doing?
Wait, can I see what the next case was, please?
So we can go look for him, Your Honor.
Not telling. Court calls case people versus Lee, Pat.
And I'm back to the people, Your Honor.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Patton, who's making his way to the podium, Judge.
Public defenders doesn't take find like 3. That's blue. Anyway, your name, sir?
DeAndre Fed.
Thank you. What are we doing?
We're asking for a brief adjournment in this matter to review discovery as well as discuss potential next steps with Mr. Patton. The people have made a waiver offer regarding a potential sentencing issue that they're agreeing to keep that open.
Correct me.
July 2nd, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls the case of the people versus Daniel Healy.
Oh, the people.
A heartbreaking courtroom battle ended with a powerful warning from the judge. The real victim was the child. Was justice truly served, or should the court have gone even further? Share your thoughts in the comments below. If you enjoy real courtroom stories and unforgettable legal moments, subscribe to The Legal Lens and turn on notifications for more shocking cases every week.
Your name?
Daniel Healy, sir.
Take your hands out of your pockets, please. What are we doing?
Your Honor, we're asking for a brief adjournment to continue plea discussions with the people.
July 9th.
Support received the bond violation report. Quantified progress report was done to change the defendant's most recent past, which is positive for an ATG.
Yes, you been drinking?
Yes, Your Honor.
You're not supposed to be kept. Did you see it?
Yes, Your Honor, I have had a chance to see the report. I too interpreted the positive for ETG not to mean that he actually just took a test, but that it came back positive for alcohol. Mr. Heelan does, as he just told you, he did drink. He is working. He has a prescription for the other substance that was indicated. He is working to make positive change. We'd ask the court to consider his unequivocal and honest response to the court in regards to the violation, and perhaps give him an opportunity to continue testing, remain outside of custody, and continue dealing with these matters.
You completed Bear River?
Yes, Your Honor. And I know I'm stuck. I've still made a lot of progress, Your Honor, and I'm not making any excuses. But I'm not using much worse things and doing much worse things. And again, not making excuses. I've just been going through it. I'm still waiting on my place. I'm just right there, and I just got changes on the way. I'm going through it, Your Honor. Again, not making excuses. I own my actions.
I think he is in line for a voucher or a subsidized housing unit, Your Honor. We thought it was going to be North Manor, but it appears it'll be Arbordale now. But he is
where?
Arbordale.
There was a clerical error, Your Honor.
No, I got it.
Your Honor, we've been here a few times over the last month or so. It looks like on 5/14, my notes indicate he had not been going to community corrections. He was ordered to appear in person, and then we understood that he was testing at home of division, but those results were not getting released to community corrections.
Right.
Then on the 21st, we're back again. The home of division results were supposed to have been sent over. I asked for a test that day, but the defendant had no money to test. The court was very sensitive to the housing needs of the defendant and did not want to mess those up. So the court allowed him to stay at liberty. The concern of the people now is that we haven't really had any. The tests that we've had since Bear River have just been since the 21st of May. We do have this positive alcohol test, and as sensitive as I am to the defendant's need to secure his housing voucher, the concerns I have are the support that he's getting. It seems like it's not a sufficient level of support to keep him from drinking or using drugs. So I am concerned about his ability to remain compliant with his bond conditions.
Your Honor, he is, as indicated, is working with Home and New Vision according to the bond report. It appears that Home and New Vision has released the results to Mr. Heelan, and those have been sent over. I didn't quite understand the language in the bond a report that they will have to apparently go through. The way I read it was they'd have to go through Home and New Vision to him to Community Corrections. I don't know if that in fact is the case. I don't know if they would perhaps agree to release them to me so I can send them along, but that was a bit of an unusual circumstance when I read it, and I got it yesterday afternoon, so I didn't really have a chance to follow through.
I tried to get them released there, so I'm trying. It's a headache. I'm trying to get them to just straight release them to all.
How often you been drinking?
Not often, Your Honor. I was actually just.
Well, no. Listen. How often are you drinking?
Not often, like a couple of times, period. Like, I'm not a big drinker, Your Honor. I'm trying, Your Honor. I'm trying so hard. I just, going through it. It was a 1-year anniversary of my father passing, and I'm not making excuses. I went off the hinges a little bit, but I'm trying to keep moving forward. Again, I haven't gone back to the worst things, and I'm proud of myself for that, but I was very disappointed in myself.
What type of treatment? You're at Home and New Vision. What type of programming are you in over there?
Intensive outpatient. I see Elizabeth Aoki specializes in intensive outpatient treatment. I just really started with her. I'm just.
How often are you seeing her?
Once a week, sir.
Anything else during the week?
I've been attending some meetings. I'm trying to find some.
How many supposed to attend?
I mean, I don't have a supposed to, but I should be going to one.
You want to stay sober.
At least.
How many meetings should you be attending?
At least one a day, sir.
And how many meetings have you been attending?
About one every 3.
So bottom line is you're not doing the stuff to even help yourself right now.
I need to step it up. I need to step it up.
So if you've been doing this, tell me why I shouldn't put you in jail today.
It'd be counterproductive for me just going to jail.
Well, what you're doing is your life is counterproductive right now.
Still making some positive progression. I am making positive progress, and I'm trying hard.
Where's your housing thing right now?
I'm right there. I've just did the new referral packet. There was a clerical error. They didn't have units available, so I kind of had to start over, but I'm right there. Like within the next week or 2, I'm going to have my own place. For the first time in a long time.
You don't get that housing, that's going to be an absolute disaster for you, isn't it?
Yes, Your Honor.
Even more so than what you're doing with your life right now.
So bad, you know. I just want my own place so much. I'll be able to work. I'd be able to take showers and actually be able to function. Just want my own place so bad.
Why are you messing it up?
That's $1 million question, Your Honor, but the flip side of that is I know it's a mess up, and I am honestly reconciled with myself, and I'm trying. And I've talked to Elizabeth. I'd like to start seeing her twice a week, but there's a full schedule. That's right now. She just got to work that in, and I really do know that I've got to step it up, and I'm willing to do that. The reason I haven't been going to any meetings is honestly, I don't have a lot of transportation, and I don't.
You can walk to a meeting. There are meetings all over. You can walk to a meeting.
Well, I'm trying to find
Not, no, I'm not,
some new one.
I am not gonna even hear that. Cause you know that's not true. You can walk to a meeting. There are meetings going on all over the place. Here's what I'm gonna do. In order to defendant is to report over to community corrections placement on Scram County.
Thank you.
And I want you to get a sign-up sheet and have it filled out that you've attended an AA meeting every day from today forward to the adjourn date. You're to bring that with you to your adjourn date, and I want to see it. Follow me? Miss a day, I'm putting you in. Comes back, take your hands out of your pockets. You miss one, I'm putting you in. I'm not even listening to any excuse as to why you didn't get there.
Sure.
If it comes back with any alcohol in your system, you're going. I'm just going to let you know how I'm going to handle it. Because I'm not sure I should be giving you this chance.
Thank you, Your Honor.
During this to July 2nd, 2026, 9 a.m.
To report to community corrections right now, Your Honor.
Yes, he needs to report right now. Don't leave here without going over.
Your Honor.
I have given him instructions.
Thank you, Your Honor.
Thank you.
Courthouse case, People versus Kenneth Perry.
David Kennedy, big for your eye.
Good morning, Your Honor. Ashley Hannibal for Mr. Perry.
Your name?
Kenneth Perry.
What are we doing?
We'd like to set a preliminary exam.
Discovery is complete.
Yes, Your Honor.
You will have their witnesses available the 30th. Preliminary examination will be set June 30th, 2026, 9 a.m. before Judge Washington.
Great. Thank you.
Courthouse case, People versus George Henderson.
And is that on behalf of the people, Your Honor?
Public defender, not here. I can review, Your Honor, on behalf of Mr. George Henderson. Mr. Henderson, state your name for the record, please.
George Henderson. Thank you.
1 second, yes.
Really? What are we doing?
Judge, we are setting this, note, we are asking for an adjournment.
What? You don't, what are you doing? Setting it for
an adjournment.
Sir, you're okay. You're fine. What do you want me to do with?
I got a green sheet, Judge. We're gonna set it, we wanna adjourn this matter. No, thank you.
Sir, I'm gonna adjourn your man. Huh?
Have contact with Mr. Henderson,
Don't try to blame us.
I'm not. All right. Go ahead, what you in?
This is not your fault. It is all her. Right? Yeah. Okay, remember that. Yep. He threw you right under the bus. July 9th.
Thank you, Judge. Okay, I'm gonna talk to you.
First day. Yeah, thank you. Said it. Calls the case of People versus Arnold Preston.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Preston. Would you please state your name, sir?
Arnold Preston.
Your Honor, we are requesting an adjournment. There is some outstanding discovery forensic interview. We'd also like to address Bob.
How long will it that part of the discovery will it take to get to them?
I sent a signed executive order to your honor this morning, so we sign up.
We have not.
We have,
Holiday some more, I would assume early next.
all right. Then I'll adjourn the matter to July 2nd, 2026, 9 a.m. Esteban.
Your Honor, Mr. Preston works for Edge Facilities. He has worked at that specific location for years. He's worked for the family of companies a total of 3 years. He's the night shift supervisor. He he is in danger of losing his employment, and he is asking that the court consider that and grant him a personal recognizance bond. He indicates that he would follow any orders of the court, including any orders regarding contact, or any other things that the court might think were appropriate to assure his presence. He is originally from Michigan. He did spend some time in Indiana, which is where the his children involved in this matter live, but he does have ties here in Michigan. And again, he's working, and this is where he's originally from. He has his mother and other family here.
Johnson, the people.
Your Honor, this is, at this time, I would object to any modification in bond. This is a criminal sexual conduct matter concerning two minor children. Although they were some time ago, the defendant does have 2 previous CSC convictions on his record.
Thank you.
So given that information, given the defendant, of course, would have intimate knowledge of where the victims are. Litigation things of that nature. Checks and modification.
Motion for bond modification is denied. Bond will continue.
Thank you.
Hey,
Anything else?
Court calls case versus the Peter Bayshot.
An assistant public defender, Nick Bukovich, on behalf of Mr. Ivesha, who should be appearing via Zoom. I believe he is under the Motorola.
What?
He should be under the Motorola.
That him?
If you remember, Your Honor, yesterday we had a similar issue.
Yes, we did.
Hello.
Hello, state your name.
My name Peter Iveza, Your Honor.
Okay. You don't have a camera, do you?
I do have camera, but doesn't know work. I don't know to work with this one. I see you guys, all of them pictures and forth, but I see you guys, but
oh, we got you. We got you. We can see you now.
All right.
Your Honor,
better than what we did yesterday.
Yeah, we have made progress since yesterday, Your Honor. As indicated on the green sheet, I would be requesting an adjournment to have him work with my mitigation team to make a mitigation report to provide to the prosecution.
When did we adjourn his case yesterday? You didn't?
I believe it was the 15th, Your Honor.
15th? Okay. Then let me do this because the day-to-day seem back-to-back days work for him. I'll adjourn this out to July 16th, 2026, 9 a.m. Bond continues.
Thank you so much, Your Honor.
Thank you.
Your Honor.
Take care.
Thank you so much. Bye-bye.
You're welcome. Take care.
Bye.
Bye-bye. What he said. Wow. Okay, there. Okay. Let's get busy. Court calls case People versus Martez Richard.
Public Defender Jay Bellinger on behalf of Mr. Richard, who approaches.
Decided to do something today. Oh, I just said. Never mind. My bad.
I huckleberry fend my cases out, Your Honor. That means if you get them to think that painting the fence is a lot of fun, then you get them to go on the record for you. Great.
Sir, what's your name?
Martez Richard.
Thank you. What are we doing?
Your Honor, I am seeking to set this matter for preliminary examination today, and then I would ask to address the bond, both cases.
All right. Preliminary examination in these matters will be discovery is complete.
To the best of my knowledge.
People have their witnesses available the 30th. June 30th, 2026, 9 a.m. before Judge Barr. As to bond.
As to bond, Your Honor, we would respectfully request that Mr. Richard be released on a PR bond subject to any reasonable conditions the court deems appropriate, including a GPS tether. Mr. Richard, from my understanding, had an initial failure to appear, which we'd argue was not the conduct of a willful disregard for this court's authority. At the time, he was homeless and did not receive notice of the court date. Since then, his circumstances have significantly changed, and he has taken significant steps to stabilize his life. He just completed substance abuse treatment, has been accepted into a sober living program where he now has stable housing in Ypsilanti. He also has reliable transportation through the sober living facility, eliminating many of the barriers that previously contributed to his instability in that regard. In addition, he also has significant family responsibilities. He's the caretaker of his disabled mother and recently welcomed a newborn into the world. A newborn, unfortunately, he has not been able to meet yet. He recently suffered a devastating loss, that of his brother, who passed away a few weeks ago as well, Your Honor. And so in addressing any concern related to public safety, he's fully willing to be placed on a GPS tether, comply with any additional bond conditions the court believes is appropriate. He's willing to utilize third parties for any necessary trailed exchanges, ensuring that there is unnecessary contact related to this matter, and fully understands the no contact order that's in effect. So we would respectfully be asking you to consider, please, a conditional release on a GPS tether and any other appropriate conditions that you might deem necessary.
So I'm going to object. According to my notes, failed to appear back in March of 2025. At the time of his failure to appear, he was present in court. People brought up bond violations at the time for calling, texting, trying to connect with the victim on Facebook. And after the court passed the case for us to try to get a report from YPD, when it was recalled, he had left. So I have concerns that he was present, heard about violating bond at the time, failed to appear, and was not back around until this year. I would have concerns that he coming back to court and his ability to follow court orders, especially given that it took him so long to come back, knowing he had left court against court orders. It was my recollection as I handled that case that day that the court was very clear that he needed to be at the courthouse and not. So I would have concerns to move the objective.
How did he come into custody from the warrant?
I turned myself over to the police when they tried to get me.
Your Honor, my client advises that he turned himself over to the police. But how did that happen?
Yeah, I was at want to tell him to.
You're at what?
Want to tell him to.
Yeah, you can tell him.
I was at the library when they approached me. They asked me my name and everything. And I told them my name, and I told
you didn't go to the police and turn yourself in.
I think he's arguing, Your Honor, that he didn't resist arrest at the time.
I will.
But that would have just been an additional charge.
Understood.
All right. I mean, but he didn't go knowing that he had a warrant. He didn't go turn himself in. That's what I need.
I was just now getting stable, and I'm back stable now, Your Honor.
And I think part of the problem at the time, Your Honor, was that was the fact that he was without a home and didn't have a lot of notice in that regard. We had issues with contact early on as well.
I just want to see my daughter. I haven't saw her since she was born because I was in here.
I understand that, sir, but
I will come back.
Well, but you didn't before. That's the problem. And so I don't know that I can trust you to come back because I passed it so that you could talk to your attorney. I recall and deal and get a cogent argument as to the bond violations, and then you just took off and didn't come back. Doesn't work that way. Motion for bond reduction is denied. Bond will continue as is. And after exam, maybe who's that before?
Judge Barr.
Barr will feel differently.
Okay.
All right. All right. Thank you.
We will address it before Judge Barr.
Borkowski versus Curtis Jackson.
Morning, Your Honor. Raymond Cook for the people.
Assistant Public Defender Davi Leba for Mr. Jackson, who is on Zoom.
State your name.
Curtis Jackson.
And Your Honor, I did have some conversations with Jackson. Yes, she's indicated to me he'd like some more time to consider his options if requesting a brief adjournment.
Adjourn it to July 9th, 2026, 9 a.m.
Thank you, Your Honor.
Court calls. Well, yeah. Sharp is it? Oh, there it is. Court calls the case People versus David Sharp.
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Sharp.
State your name, sir.
David Warren Sharp.
Thank you. What are we doing?
Your Honor, we're asking for an adjournment. We requested some additional video discovery.
During the matter, will that be available soon? July 2nd, 2026, 9 a.m. On continue. Thank you.
Thank you.
Court calls case People versus Eric Jackson.
That's all the
I got a Peter bond on the charge. Yeah. Okay.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Jackson. Would you please state your name?
Jackson.
Your Honor, Mr. Jackson has been working with our AIM division and had an appointment with the midnight specialist that he had to reschedule. We're requesting a 2 to 3 week adjournment so that we can get that letter done.
July 9th, 2026, 9 a.m. Thank you, Your Honor.
Thank you, Your Honor.
On continue. Court does call the case People first. Taiwan Grid.
At the bottom of people, all matters. But Michigan.
Who?
Actually, I can really, Your Honor, standing in for Miss Stephanie Candace, who stepped outside. Mr. Beginning for the record.
Taiwan Griggs.
Judge, I don't know if the court is in receipt of the documentation.
The
Corrected,
yes, we have it. All right. And I believe she wanted, well, she's here now finally.
I'm sorry, I was in the booth with Mr. Briggs. My apologies. We are asking that the 24 case be set for a preliminary exam. The prosecutor is working on discovery as to the 25th case, and the amended information or the amended forensic order is in with the court.
Oh, the 24 case you want set for exam, discovery is complete in that one.
Yes.
And people have their witnesses available the 30th.
I have not checked that date, but we'll try, Your Honor.
All right.
What starts as a routine custody hearing explodes into an emotional courtroom showdown as two parents wage war over their child. But the judge shocks everyone by revealing the real victim, their 8-year-old daughter. His powerful warning leaves the courtroom silent, turning a bitter legal battle into an unforgettable lesson about the devastating cost of parental conflict. If you enjoy real courtroom stories and unforgettable legal moments, subscribe to The Legal Lens and turn on notifications for more shocking cases every week.
So the 24 case that will be set for a preliminary examination June 30th, 2026, 9 a.m. for Judge Washington. The other matter, what's the timeline on discovery?
Your Honor, I think it's either going over today or it went over yesterday, so very
Okay. And then I'll set that one. I'll adjourn the probable cause conference to July 2nd, 2026, 9 a.m.
Thank you, Your Honor. My client is asking that he allowed to be released to the care and custody of his sister on tether. She is trying to, she was his guardian. She's not his guardian anymore, but she is accepting him back to the house. He does want to go back into inpatient treatment. The court has signed an order allowing that. His Wayne County was order his Wayne County hold was cleared. They gave him a PR bond in that matter. And he has the paperwork to show the PR bond. He wants to go home. He has health care. He has SSD, I believe. So he has the ability to get into treatment. So he's asking that he be allowed to be released as well, and he'll go directly into treatment once he wants to take care of a few things. To be clear, he discussed his personal care. He's very he wants to get that together. There's things that he discussed with me, Your Honor.
Your Honor, we've addressed bonds several times on
Absolutely.
cases. I will note just if I recall correctly, the court did grant the release treatment for the people's objection, which is fine. But I will also note, and I think it's worth considering by the court, that the defendant did get the 2025 resisting and obstructing case the day after we missed court on the 2024 assaulting, resisting, or obstructing case. I think that if it's going to be anywhere that's not in custody, would need to be at a treatment facility because he doesn't appear to be able to remain law-abiding when he's out on his own.
I'm going to, at this point, as I have before, deny the request for bond. Bond will continue in both matters.
Thank you, Your Honor.
So, can I ask a question? So I would be released to treatment then?
No, the release to treatment is still in place. If treatment's available, if they get it bad, you'll be released to treatment.
Yeah, they told me that it'd be anywhere between this time and Monday, but
if it happens, then it will happen. But
it's the court is understands that you have been. He just wants the court to know that he has been screened, that in bed is available by Monday, he hopes.
yeah, then if that happens, then he can go. I did that over the people's objections because the reality, Mr. Griggs, that's what you need. You need treatment.
Thank you.
And so I'm willing to allow the release under those circumstances so you can get the help you need.
I comprehend.
If you're depending on the length of that program, if he is released on Monday, with our examination being on the 30th,
right?
I'm not sure whether or not he'll be available to come. So if defense counsel gets any information about that, they could let us know. So call us
and get that moved.
Yes.
Right. Thank you.
Information for him.
Court calls case people versus Roderick Jacob.
So now we have people brother.
So Hutchins on behalf of Mr. Jacobs, who's present and standing to my right, Your Honor.
My name is Roderick Jacobs.
What are we doing?
Your Honor, we're requesting an adjournment for additional coverage.
So the public defender's office, that's what you're asking for, isn't it? No, I'm kidding. All right. How much time did you need?
It should just be a couple weeks would be fine.
July 9th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you.
Court calls case people versus Robert Schellberg.
Listen, on behalf of the people, Your Honor.
Assistant Public Defender shall be carried out in room, Your Honor. President Schellberg, who is approaching. Mr. Schellberg, state your name for the record, please.
Robert Gerald Schellberg.
Thank you. As you're taking back, I'm going to pass. Got to have a question answered about an amended complaint.
Okay.
Back out. All right.
Thank you, Judge.
Is that person? Probably not. Court recalls case people versus Dean Hodder.
Question calls to the people.
It's Michael Gaddy, Assistant Public Defender with Mr. Hodder, who is approaching as I speak. State your name for the record, sir.
Dean Hodder.
Couple things you want to adjourn.
Yes, Your Honor. I did get a copy of the bond report.
Out of your pocket.
Okay. I did get a copy of the bond report, Your Honor. As it indicates, Mr. Hodder has gone to community corrections. He's made contact with them. He's gone and has been unable to test for financial reasons.
I go test it. I'm going to come to court first.
He reports that he was going to test today, but they told him to go to court first.
You have the money to test?
I got $10.
Pardon?
I got $10 on him. Oh, yeah.
Okay, you're going to have to figure out how to get this done, sir, but go over to community corrections and test.
Okay.
Okay. I'll adjourn this out. How long an adjournment did you need?
Yeah, I believe that this is a situation where the people need to contact the complaining witness, if there's a potential resolution here, so.
July 9th.
July 9th.
July 9th.
July 9th. Thank you, Judge.
All right. But get yourself over there to test, all right? But
Okay.
Notice.
court calls the case People versus Darius Jones.
Hasn't felt to the people.
Enzo Hutchins on behalf of Darius Jones, Your Honor, who's present and standing to my right.
All right. Your name? Darius Jones. You're asking for an adjournment.
That's correct, Your Honor.
July 9th, 2026, 9 a.m. Bond continued.
Thank you.
Court calls case People versus Kawanda K. Thomas.
Good morning, Your Honor. Ashley Hannibal Thomas.
State your name.
Corey Thomas.
What are we doing?
Would like to preliminary exam.
All right. Discovery is complete.
Yes, Your Honor.
And people would have their witnesses available the 30th. All right. Preliminary examination will be set June 30th, 2026, 9 a.m. before Judge
Bar.
All right.
Bond continued. Thank you. Court calls case People versus Walter Junius.
Julie Gaines, Senior Assistant Public Defender, representing Mr. G. Would you please state your name, sir?
Walter Jr.
Your Honor, we have requested some additional discovery, asking if there is dash cam and body cam footage with regard to these allegations. We're asking for an adjournment.
July 16th, 2026, 9 a.m. Bond continued.
Thank you.
Thank you, sir.
You, sir.
Court calls case People versus Ches Williams.
And we have. Oh, Shay Williams.
Shay Williams.
Yes.
It's Shay? Right.
Assistant Public Defender Chinazi Carey, I can really, on behalf of Mr. Shay Williams. Mr. Williams, state your name for the record.
Shay Anthony Williams.
Shay?
Yes, Shay. Yes. Yes, sir.
Really?
Apostrophe E.
Just change.
Apostrophe E.
Just change. All right. Just change how it's pronounced.
So it's
trying to do
apostrophe.
Trying to do a French thing.
Yes, that's pronounced.
All right.
Oh, not spelled. Okay. It's French, Judge.
It's French? I know. That would be French.
Yep. Your Honor, we respectfully request.
Was it French when you were
Probably not.
named you?
I believe so. That's because she named me after some place in Detroit. It was a restaurant, I think. I don't.
You got named after some food? Okay.
That's probably.
No, that's all right.
Have you been there?
I get it. So, okay, so it is French. That's what I said. All right, what are we doing?
Your Honor, we respectfully request that this matter be set for preliminary exam.
Both of them?
Yes, Judge, both matters.
All right. Discovery is complete on both matters?
To our knowledge, yes.
And we'll have their witnesses available the 30th?
Yes, sir.
All right. Preliminary examination will be set June 30th, 2026, 9 a.m. before Judge Washington. Court calls the case People versus Jason Martin.
Your Honor, Raymond Cook for the
Morning, Your Honor. Ashley Hannibal for Mr. Martin, who is appearing by Zoom.
Yep. Martin, can you state your name, please?
Jason Martin.
Thank you. What are we doing?
I'd like to set a preliminary exam.
All right. Discovery is complete.
Yes, Your Honor.
And people have their witnesses available the 30th?
We'll do our best, Your Honor.
Preliminary examination, June 30th, 2026, 9 a.m. before Judge Barr.
All right, thank you, Your Honor.
Thank you.
All right, thank you, Your Honor.
You're welcome, sir. Clerk calls the case, People versus Larzell, Washington.
And Assistant Public Defender, Chinazi Carey, I can rule, Your Honor, on behalf of Mr. Larzell Washington. Larzell, state your name for the record, please. Sorry.
Good morning.
Morning.
Larzell Washington.
That's French. No, good.
Right. Judge, you're asking for an adjournment. We're negotiating with the people.
All right. Hearing matter, July 16th, 2026.
Thank you, Your Honor.
That work for you, sir?
Yes, sir.
Okay. Great.
Thank you.
You're welcome.
For next.
Court calls
Paper.
case. Coming up, or
Yeah, he's refusing.
he's refusing again. Court calls case, People versus Dennis, or Zachariah, or Ruska Dennis.
Jacob Kennedy for the people, Your Honor.
Ashley Hannibal for Mr. Krishka Dennis, who is not appearing.
Yeah, he's refusing to come up.
Yeah.
What they do with this other one? Do they think we're all waiting on competency anyway? No. Okay. I think these are all separate problems. They're these both out to July 16th, 2026, 9 Thank you.
Thank you.
Okay.
Court calls the case, People versus Romeo Smith. He's in investing.
He also.
Romeo Smith? Yeah, but I need an attorney. Cannon, you're not doing anything. Step up to the podium. Oh, Pete.
Thank you.
That was fault.
All right. I would. Michael Gaddy, Assistant Public Defender.
Your client doesn't want to show.
Your Honor, we'd request an adjournment in that.
I'll adjourn it over to the July 16th, 2026, 9 a.m. Court calls the case, People versus Mamadou Diallo.
Assistant Public Defender Donzi Leap on behalf of Mr. Diallo. And my understanding is that the facility where Mr. Diallo is housed has not logged in.
They did not.
And Your Honor, I have attempted to reach out to him there. I do have a number for the unit manager that I have left 2 messages for, and I have not heard back from that either.
We have to give them what?
4 weeks.
So why don't I adjourn this then today? Let me adjourn it to the July 23rd.
July 23rd, Your Honor?
Yes, sir.
Thank you, Your Honor.
Bond continue. That's all I have. But there's one recall.
I wonder where it's going to.
You
Is
said-
it the last case? We can call it, Judge. We're ready.
Bless you. We're
Assistant Public Defender, Chinazi Carey, I can rule on behalf of Mr. Shellberg. Judge, can we approach?
you may.
Thank you, Judge.
Conference in this case. There has been an amended complaint filed, which has extended the dates and added a charge of witness intimidation, bribing. My understanding is the addition of that charge, there's no objection for the defense to that charge at this point. Not claiming that defendant certainly is guilty. Have no problem with the adding of that charge, correct? Excellent.
Correct, Your Honor. Yes,
All right, and as to that charge, your client waives formal reading and stands immune.
he does, Your Honor.
All right, court will enter a not guilty plea as to that charge. requesting a preliminary examination. I will set a preliminary examination in both of these matters, discovery being complete, but there is additional discovery, which are part of the phone calls that still have to come to defense as well as supplemental report. Everybody's aware of that.
That's what we've been told, Judge.
And I will set, and the people hopefully will have their witnesses available the 28th of July. Doesn't bear on the defendant's in custody status. So I'll set this for preliminary examination, July 28th, 2026, 9 a.m. That is before me.
If I may address that.
Man,
Since the court has revoked Shelberg's privileges, he has contacted the victim from other pins. There are 31 plea calls to the victim since he's been arraigned, and almost all of these calls would include things that would go towards this witness interfering or bribing, charge along with wrongdoing for the sheriff and folks. I'm going to the joint deal that is taken care of. They're going to let me out if he's interested in me getting out. Otherwise, I'm talking for 7 to 10 years. He also has been instructing her on things to say, and then after those instructions, she reaches out to our office. He also has instructed her to contact the court's chambers to give them what he's telling her to say. He's also instructing her to try and visit him at the jail by using her sister's identity. I mean, the bond violations at this point are so flagrant, it's unbelievable, given that his privileges were revoked. He was told not to contact her. And in those original calls, they are also witness interfering, bribing, promises of marriage, promises of a better life, things of that nature. There's also, the court told him, no contact is no contact. He deliberately goes to other inmates' pins to continue that contact and continue forfeiture by wrongdoing type calls, instructions, contact, ways to get in contact around the phone calls, visits in person, telling her to come to court. And then after she's at court, set up a visit to meet with me at the jail. I mean, it's at this point, it's ridiculous, but I wanted to bring that to the court's attention, and it is the people's attention for the exam to potentially have a motion for forfeiture by wrongdoing filed as well, given these calls and the tainting of the victim's testimony and the interfering with this criminal case.
So, Your Honor.
I've already revoked his bond.
Correct.
As well as his phone privileges, and that doesn't seem, you just don't seem to get it. This is not, this is just not going to go well for you. You keep playing these games. So what I am at this time is I'm ordering that all visits except a professional visits are hereby revoked for the defendant. I have no visitors. Just keep playing with me. All right. Thank you.
Thank you, Your Honor.
You bet. That's it.
But I'll figure it out.
All right. Wrote it down. Got to be written. It's got to be written on D4. All right. I think that's it. Wow. Perfect timing. Despite presence of Kennedy. Of course, I heard what Ann.
Well, Your Honor.
I heard what Ann was saying.
Jessica McFarland requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Michael Gaddy.
Really? How is he as a supervisor? Okay. Permission to practice is granted.
Oh.
Wow.
Brother, friend, I get that same review.
Yeah.
We have the defendant state their name.
Rahaska? Oh, they're in there doing it now. Thank you, officer.
You're welcome.
Mr. Oscar, state your name, please.
Steve Oscar.
All right. And what are we doing?
We are requesting to adjourn for further negotiations with the people.
We have a green sheet.
Yes.
It's going to hold it.
Sorry.
Eddie, take.
No.
Let's see. July 9th work.
Yes, Your Honor.
Matter will be adjourned without objection to July 9th, 2026, 9 a.m.
Thank you, Your Honor.
Sure.
Bond continued. Thank you. Court does call the case of the people versus Sarah McCormick.
Good morning, Your Honor. Andrew Cito, PH 7447 on behalf of defendant Sarah McCormick.
Mr. McCormick, can you unmute? State your name.
Hi there. I'm Sarah McCormick.
Thank you. All right, what are we doing?
Good morning, Judge. I spoke with the prosecutor, and me and the prosecutor have been working together, and she offered me a deal to reduce this down to a misdemeanor for controlled substance use. I haven't had the chance because we just spoke with the prosecutor yesterday. It was pretty late, and so I just need to.
An adjournment?
Yeah, just an adjournment so I can just go over this with my client and then come back here for the conviction.
Will July 2nd work?
Yes, Your Honor.
Probable cause conference will be adjourned July 2nd, 2026, 9 a.m. Bond continued. Thank you, Ms. McCormick.
Thank you.
Court calls the case, people versus Matthew Kennedy.
Good morning, Your Honor. May it please the Honorable Court, David Burgess, on behalf of men.
Your name, sir?
Matthew Kennedy. Your Honor, we are asking for an adjournment of the probable cause conference. My client did complete Bear River, and it might work into the plea, but the prosecutor needs the proof of that, so I need to get it from my client.
All right. Couple of work.
Yeah, I did want to address bond if we could, just briefly.
I'll adjourn these matters to July 2nd, 2026, 9 a.m. As the bond.
Thank you, Your Honor. Judge, my client failed to appear on a date. He had called me later that day, got his dates mixed up. Tried to walk him in on a Wednesday, but he was not able to meet me at the one Wednesday. I was able to do it that day, but did complete Bear River, Judge, and he did contact me. These aren't assaultive cases. I understand the concern the court might have, but does have stable residence area, and I think he will return, Judge, based on.
So how do you come into custody?
I don't. How'd you get?
I was at work. Picked up at work.
Yeah, picked up at work.
They just came and got you?
Yeah, I didn't cut my tether off or nothing. I didn't abscond. I didn't. He had a tether on, Judge. I mean, yeah, it was pretty easy to find, I guess. So.
Yeah, didn't die or nothing. I kept it charged. I kept doing my weekly check-ins. I kept going.
Why was the first thing that came to your mind cutting off your tether?
No, he said he didn't cut off.
No, I know he didn't say it. Well, why did that come to mind? Never mind.
Because I didn't.
It's context, Judge. That's all it is. Context.
Yeah, like I wasn't trying to go on the run.
Oh, sorry. You're good.
Anything from the people on the.
No, you're wrong.
All right. What I will do is I will reinstate the defendant's previous bond in this matter.
Thank you, sir.
All right. Thank you.
Thank you. Hey, you know,
You want me to change my mind or?
No, he said thank you.
Oh, I know what he said. If it doesn't go, I'm going to change my mind.
Leaving quickly.
Yes. Court does call the case, People versus Robert Anderson.
Your Honor.
Good morning again, Your Honor. May it please the Honorable Court, David Burgess, on behalf of Robert Anderson, who's appearing via Zoom, Your Honor.
Hello, Robert Anderson.
Okay, thank you. All right, what do we do?
Your Honor, the people have indicated to me that there's some additional discovery we're going to have to review and obtain prior to the exam, so we're requesting another adjournment of the probable cause conference.
How much time are you going to have?
You know, a couple reports from YPD.
All right.
Which is fine, Your Honor.
Probable cause conference, July 2nd, 2026, 9 a.m. Bond continued.
Thank you.
Thank you. Court does call the case of the People versus Charles Johnson.
Your Honor, as about the people.
Oh, on behalf of Mr. Johnson, who'll be approaching the podium and standing to my right. Mr. Johnson, once you get up here, please state your name for the record.
Was that supposed to be her case and you took it, Felta?
Yes, Your Honor.
Lady, where are you from? Okay. Don't let her do that to you. All right, go ahead. I'm sorry. Your name, sir?
Charles Bernard Johnson II.
And Your Honor, at this time, we are asking that the matter be set for exam.
Discovery is complete.
To my knowledge.
What?
We're on June 30th.
People have their witnesses available June 30th? All right. Preliminary examination will be set June 30th, 2026, 9 a.m. before Judge Washington.
Thanks.
Bond will continue. Thank you. Court calls the case of the People versus Amanda Brown.
Morning, Your Honor. Written.
Morning again, Your Honor. May it please the Honorable Court, David Burgess, on behalf of Amanda Brown, who's approaching.
Your name?
Amanda Brown.
All right, this is a waiver.
Yes, Your Honor.
Ma'am, you're waiving your right to a preliminary examination?
Yes.
A courtroom full of surprises quickly turns into pure chaos as one defendant almost loses his freedom after missing court, another casually jokes about cutting off his ankle monitor, and the judge instantly calls him out. As case after case unfolds, shocking bond decisions, unexpected courtroom humor, and tense legal moments keep everyone guessing. Just when you think you know what will happen next, the judge delivers another twist that changes everything. Stay until the end with the legal lens for every unbelievable courtroom moment.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. You understand that you'll not have that hearing, you'll proceed to circuit court for further proceedings.
Yes, sir.
People also waive their right? Yes.
Not had official offender notice as well as an agreement. My understanding is that it's currently on probation at circuit court. There would be an agreement to have her back in current probation, no upfront jail with her current circuit court.
That's our understanding as well, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Burgess.
Waive formal reading, stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
August 11th at 1:30 with Judge Company.
August 11, 2026, 1:30.
Okay.
Bound continued.
I'll call you.
All right, I'm done.
Court calls case of People versus Douglas Hill.
Over for the people, Your Honor.
And Assistant Public Defender Zach Venue with on behalf of Mr. Hill, who approaches on the case ending in 163.
Morning, Your Honor. Jay Grant Miller, P58658, on behalf of Mr. Hill on 2111.
Douglas Hill.
Thank you. Both of you are requesting an adjournment.
Your Honor, yes, we're trying to keep the cases together, and I believe I spoke with the prosecutor this morning, and she's still waiting on a CCTV video. And as soon as that happens, we'll set for exam.
How much time are we going to need to get that?
Spoke with the agency yesterday. They indicated that it was just processing.
It was on.
The request, they had uploaded it, but it's processing.
Got it. So a couple weeks, you think, gentlemen?
I would defer to the prosecutor, Your Honor.
Pardon?
Good, Your Honor.
All right. Probable cause conference will be adjourned to July 2nd, 2026, 9 a.m.
Thank you, Your Honor.
Bound continued. Thank you.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Morgan. Is it G-Lander?
Morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Morgan Jalander.
Your name?
Morgan Jalander.
You're requesting an adjournment?
Yes, Your Honor. 2 weeks is okay, Judge.
It work.
I think I'm.
Probable cause conference will be adjourned July 2nd, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case People versus Safara Kent.
Jacob Kennedy for the people, Your Honor.
Michael Gabby, Assistant Public Defender on behalf of Mr. Kent, who's approaching, Your Honor. State your name for the record.
Safer Kent.
You're requesting an adjournment. Will 2 weeks be enough?
Would that be enough to get him
Oh, you need,
Your Honor, I believe there's some additional charges coming.
That is correct.
So I don't know if they'll be able to get him arraigned on those, but I would think 2 weeks, depending where they are in the swear-to process.
My understanding that swear to is going to take place this November. So
okay, is he then set to be, the swear to will happen, is he set to be arraigned this afternoon?
that, no, Your Honor, just swear to.
Purchase of offense is complete. Right.
That's correct. There are 3 additional.
Gotcha. Okay. And so that this wasn't on where the officer was on call.
No, but for this.
Got it. Okay, so that's where two is going to take place. He would then have on those charges. I don't. You want me to put it out 2 weeks or 3? Because here's the reason I'm asking. I don't understand if the swear to is going to happen. He's in custody. I don't know why we couldn't add him to the list to have him arraigned on those 3 charges this afternoon and then set it 2 weeks out. But if you don't want me to do that,
That's fine with us, Your Honor.
All right.
I agree. Word too about what exactly is going to happen this afternoon to see that maybe they can get him on the list to be arraigned as well. Certainly.
Zach Ward's involved.
Not. No.
If he's involved, this isn't going to happen.
I'll make sure he knows that.
All right. So if the officer's going to swear it out today, we communicate with the magistrate to see if they can get him arraigned and then set it for the 2nd? So I'll adjourn this out, probable cause July 2nd, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Dominic Brewer.
Morning, Your Honor. My name is Cook for the People. Good morning, Your Honor. Capital on behalf of, but not with Mr. Brewer. Your Honor, it's my understanding that Mr. Brewer was picked up in Canton yesterday. Because of a hold that he had already. So I think it's my understanding, I believe he's in the Wayne County Jail or in the Canton lockup. I spoke to a family member yesterday late.
Well, we have it that yes, he was picked up. And they filed a conditional bond violation.
Okay.
All right.
Okay. Thank you. I wasn't aware of that bond violation, so thank you for that, Your Honor.
This is the report. I think this is the Canton report that they then filed with this court, took him into custody down there.
Understood.
So at this point, what I will do though is I'll issue a bench warrant for his failure to appear. That way we can go get him. Bond will be set in the amount of 10,000 cash surety.
Thank you, Judge.
You. Court does call the case of the People versus Lorenzo Murphy.
Great, thank you, Your Honor.
Good morning, Your Honor. Please, Honorable Court, David Burgess on behalf of Lorenzo Murphy. Your Honor, we're asking for an adjournment in this matter. I just got this case. I was just appointed on it.
Are you on both cases?
Yes, Your Honor.
Need 2 weeks.
Yes, Your Honor.
July 2nd, 2026. Bond continue.
Thank you,
sir. Court calls the case of the People versus Daryl Howell.
People. Good morning, Your Honor. Nathan Coulter requesting to
Okay, permission to practice is granted.
Edward Rodriguez on behalf of Carol Howell. Your Honor, I just was appointed. The contact information is not good. I don't have an email. I'd asked for an adjournment just for purposes of contact with him. I do have an address. I did mail him a letter yesterday, but I haven't got any confirmation back. I know he's on probation in Wayne County.
He's on probation in Wayne County?
On probation in Wayne County. So in the event that I reach him, if the court were to adjourn it, this is the first PC.
I understand that, but I think Given the nature of the charges, I'm going to issue a bench warrant for surety to appear.
Okay.
Bond will be set at a 10,000 cash surety.
Thank you.
We'll issue immediately. Thank you. Court does call the case, People versus Christopher Madison.
Bring it over to the people.
And Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Madison.
In both matters.
In both matters, Your Honor.
Your name, sir?
Christopher Madison.
Thank you. You're requesting an adjournment.
Well, Your Honor, I did speak to Mr. Madison yesterday. He indicated he may not want the services of the public defender anymore. So
what? He doesn't want the services of the public defender? I'm going to hire his own?
No, I
Go ahead.
do a letter and I plead guilty on all charges, sir. So I figured I didn't need a public defender to plead guilty.
Okay. Mr. Madison? Did I receive this letter? I don't think so.
Top of my head, it did not sound good.
Yeah, I don't know that I received a letter from you.
Oh.
Yeah, and why do you want to plead to 2 felonies?
Because I'm 5 years, sir. I was under the influence of drugs.
Okay, hold on. I don't want you to, well, just listen to this, Mr. Madison. I don't want you to say anything about the charges.
Okay.
Okay. I'm just trying to figure out why you want to proceed in that fashion, but hold on a second. Mr. Bukovich.
Your Honor, as I said, I don't want my client putting anything on the record that could incriminate himself. Obviously, he cannot plead at this stage. We're at the PC stage, which you cannot plead to a felony at the PC stage because this is a.
You can. Yeah, I don't take the plea.
You're not going to take the plea. So ultimately, I believe at this stage, our best option would be an adjournment for us to have time to consult with our client about the implications of a plea.
Let me ask you this, sir. If you're trying to get this done with.
Yes, sir. I'm trying.
Okay, hold on. It's not going to happen however it resolves itself. It's not going to happen less quickly or more quickly if you have an attorney, right?
Okay.
So I don't know. I think having the public defender is in your interest. The important thing, more so than it being quickly, is that all of your rights as you go through it and you go, whatever your decision is, your decision. But that to make sure that all your rights are protected. That's part of the reason that they're there and that your interest is protected. Okay. So I think what you should do, I'm going to adjourn these out a couple weeks. Okay. And then let you talk to the public defender, tell them what you want to do and talk it through with them. Okay. Fair enough. Okay. All right. I'll adjourn these to July 2nd, 2026, 9 a.m. Thank you, sir.
Thank you, Your Honor.
Court calls case, People versus Deontay Jordan.
Morning, Your Honor. Bring Cook to the people.
Good morning, Your Honor. J. Grant Miller, 58658 on behalf of Ms. Jordan. Your Honor, I was communicating with my client last night. He indicated having some transportation problems. He lives in Lansing. I encouraged him to get the bus down here. I would request
a whole bus thing, but go ahead.
Well, I did suggest the flyer does travel from Lansing to Ann Arbor, and then he can get the number 4 down here. Literally, I texted that to him, Your Honor. Not here. I understand the people are probably going to request something.
Bench warrant will issue for defendant's failure to appear. Bond is set in amount of $10,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Jason Smith.
Ready, Your Honor.
Morning, Your Honor. Bring Cook for the people.
Good morning, Your Honor. James Fifelski appearing on behalf of Jason Smith, who is approaching. Can you please state your name?
Jason Smith.
Thank you. Your Honor, this is our first PCC. I'm asking for an adjournment for discovery and investigation on this, please.
July 2nd, 2026, 9 a.m. without objection.
Thank you, Your Honor.
Bond continues.
Thank you, Judge.
Court calls case People versus Janine Lebrel.
Morning, Your Honor. Raymond Cook for the people.
Praise.
For the record, Your Honor, Stuart Collis on behalf of Ms. Lebrel, who is approaching and coming to my right.
Hello, your name?
Jean Lebrel.
Thank you.
Your Honor, today for PCC, we are asking for an adjournment of this matter to do some further discovery. There's some videos that we need as well as some negotiation in this matter.
Probable cause conference will be set July 9th.
Very well. Your Honor,
26, 9.
I have a brief request on the bond. My client has to go out of state for her nephew's birthday in Columbus, Ohio. And while I am sad that
to Ohio,
I know, right?
No, go ahead.
It's late June, and she obviously will be returning back where her partner home is. But
do we have travel dates?
Yes.
Yeah, it's the last Sunday in June for my nephew's first birthday. And I'll be staying with my parents.
So the 28th?
The intention is to drive down on the Saturday and then come back the Monday.
Saturday, the 27th.
So 27th to the 29th. Any objection from the people?
No, Your Honor.
All right. Her bond will continue. When you get me, you're doing it. And then I will allow her to travel to Ohio for those 3 days. Enjoy.
Thank you very much, Your Honor. See you on the 9th. Thank you.
I'm sorry, Miss Zenda. I'm really sorry that you're from Ohio. Court calls the case. People versus Wardell Smith.
That is it. On behalf of the people, Your Honor.
Morning, Your Honor. Robert G. Kill on behalf of Wardell Smith.
Much better person having been in Michigan, but
Today's time for PCC.
Your name, sir?
I'm sorry. We set this for exam.
Discovery is complete.
Yeah, it's a reauthorization. Everything's the same. Yes.
All right. People have their witnesses available the 30th.
We'll do our best, Your Honor.
All right. Preliminary examination will be set for June 30th, 2026, 9 a.m. before Judge Barr.
Judge, may I make a bond argument?
May.
Judge, because this is reauthorization, the victim, who is the mother of his children, never showed the first time. That being his wife. I'm sorry, his wife. Since he's been in jail since April 21st, he's done 3 weeks of Dawn Farm program. He could do that outpatient. He'd also continue with CMH. He could do that outpatient. Done a lot of really good programs in the jail. 12-step, the DV1, DV2. I know what the prosecutor is going to say, that he called the FBI. He admits he called the FBI. He was worried about his children. After he called the FBI, his son then called him, say, "Dad, everything's okay." He tried to cancel the FBI appointment. So again, it wasn't.
But that, I've heard this before. It wasn't just the call to the FBI. There were other calls that were also initiated by this defendant regarding police involvement.
Careful, what do you want to say? It was for the benefit of your children? Yeah, Judge, he did call, what, Pittsfield?
Yeah.
He did call Pittsfield. Again, it was concerned about his children, Judge. Again, there's a serious charge. We understand that, but my client could live with his mother in Ypsilanti. She's already said it's okay for him to live there, even if it were on tether. The other issue is, Judge, and I know this really doesn't go to the case, he has a lawn business that all his equipment is in a storage area that's about to be repossessed and sold out. And we're asking the court to please consider just a reasonable bond for this man. He will stay away from the victim. And the calls he made were for the benefit of his children. who then called dad, said everything's fine so far.
Once again,
I'm gonna object. While the defendant may say it does work for the benefit of those children, some of those calls that involved him reporting a shooting, having law enforcement respond to that house for those children, basically, in a sense, swatting that residence for a shooting that did not occur. Beyond that, he did call the FBI, and there were also allegations of drug use while he was out on bond. I also have concerns given in one of his calls on the 15th, he mentions, I want to know if you can help me get back to good graces with my family, that I have a child with my wife. Tell her not to cut me out of the picture. Tell her that I still love her and I need her back now. I need some support. So I have concerns that he has shown this court time and time again that he cannot follow bond and is a danger to not only the victim, but the community and law enforcement by abusing their resources and having them to respond to things that are not happening. And also harassing this victim. And I mean, at this point, it was real because she came back around and was on board because she was in fear for her life because of this defendant. So I think at this point, bond is appropriate, given that he has shown this court he cannot follow the orders of the court. And is still even now attempting to try and get a hold of this victim, wanting to call her directly and having other people in his family reach out to her.
that's what I'm trying to do.
Judge, he said he was never trying to get a hold of the the victim. It was regarding his children. But this is the case. She never showed the first time. And again, I don't know if she's going to show the second time, but the court should.
But I've heard this bond argument before. I mean, I don't know of any circumstances that have changed from the court's perspective. It's actually gotten worse, quite frankly.
A reasonable bond to protect society.
I think the bond is reasonable. Motion denied. Court calls case, the People versus Tariq Wilson.
People.
Assistant Public Defender Nick.
All right.
Okay.
Okay.
Thank you.
Welcome.
Thank. Mr. Wilson, can you state your name, please, sir?
Derek Wilson.
Thank you. You're asking for an adjournment.
Yes, Your Honor, I filled out the visit application. I'm just waiting for a response. So
How fast do you typically respond? Do you know?
Well, they told me it would take 2 days to process that, but apparently that may not have been true because I sent it more than 2 days ago.
All right. He's in MDOC.
Yes, he is.
I think the court's familiar with those. It could take weeks.
Yeah. All right. Let me adjourn this out to July 16th. On effective at its custody status, July 16th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Court calls case of the People versus Natasha Brazelton.
Morning, Your Honor. Raymond Cook for the People.
And Assistant Public Defender Nick Bukovich on behalf of Ms. Brazelton. Should be appearing via Zoom.
Not checked in.
Yeah, I did speak to Ms. Brazelton this week. We were playing a little bit of phone tag. We do have a finalized offer, so I cannot explain her lack of appearance here today. However, I did speak to her this week, so I would be requesting an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount $10,000 cash surety. Court calls the case People versus Lowry Shinavar.
Thank you for the People.
Good morning, Your Honor. Sam Bernstein with and on behalf of Kevin Shinavar Lowry.
Yes, it is. I'm sorry.
Kevin William Shinavar Lowry Jr.
Your Honor, we're hoping for an adjournment to review discovery.
All right. How much time? 2 weeks would be enough for it?
I think so, Your Honor. Yes.
Will be adjourned to July 2nd. Bond continue.
Thank you, Your Honor.
Court calls the case People versus Austin Bird.
Hello.
Morning, Your Honor.
Oh, here we go.
Gaga requesting permission to practice pursuant to Michigan Court Rule .120 under the supervision of Assistant Public Defender Nick Bukovich on behalf of Mr. Bird.
Permission to practice is granted. Sir, state your name. Mr. Bird?
Yes, Your
Can
Honor.
you state your...
Austin Bird.
Thank you. All right, what are we doing?
We're just requesting an adjournment for ongoing plea negotiations, Your Honor.
Adjourn this matter to July 16, 2026, 9 a.m. Bond can.
Your Honor.
Thank you.
Court calls the case People versus Ayad Abulez.
No one for the people, Your Honor.
Your Honor, Assistant Public Defender Davi Lebo on behalf of Mr. Abuelas. Mr. Abuelas, can you tell the court your name, sir?
Iyad Abuelas. Good morning, John.
All right, what are we doing?
Andrew, I'm going to request you to adjourn both matters for discovery, and I would like to address bond as well.
Probable cause conference, 2 weeks, or you want 3?
I would ask for 2 weeks, Your Honor.
July 2nd, 2026, 9 a.m. Go ahead, Esteban.
Thank you. With regard to bond, Mr. Abuelas has told me that he has stable housing located in Ypsilanti. He does indicate to me that he has some health issues, needs a medical appointment with regard to that next week, as well as an appointment with a psychiatrist he's going to be needing to reschedule as a result of his custody today. He also indicates to me that he has 2 children, a 1-year-old and a 3-year-old, and he's quite anxious of being separated from them, and he anticipates they feel the same way. They're currently staying at home with his wife. If we'd have no objection to home confinement tether, and Mr. Boyles indicates to me that he could post up to $1,000 in bonds, so we'd ask
how much?
Up to $1,000, Your Honor. And so we'd ask the court to consider a personal bond or in the alternative, a 10% bond that Mr. Boyles will be able to post.
Response.
My understanding that the defendant's like just remained on new charges yesterday. And
yes,
criminal history. If the court was inclined to release him, we would also be asking for it. Okay.
Well, given that argument, the court will modify the defendant's bond to a $10,000 10% bond. Defendant must be placed on a GPS home confinement tether prior to his release.
Thank you, Your Honor.
Yeah. Thank you. Court calls case People versus LaShawn Charles.
Your Honor, agreement.
What started as a routine court hearing turned into a shocking courtroom moment when one defendant never showed up. As case after case moved forward, the judge suddenly realized the defendant was missing with no explanation. Within seconds, the courtroom atmosphere changed as the judge issued an immediate bench warrant and set a $10,000 bond, making it clear that missing court is never a small mistake. One missed hearing instantly turned into an arrest order, proving that ignoring a judge can make legal trouble far worse. This tense courtroom moment is a powerful reminder that in court, every appearance matters, and one absence can change everything. Like, comment, and subscribe to Legal Lens for more crazy courtroom drama, and be sure to subscribe to the Legal Lens and turn on notifications so you never miss another fascinating courtroom story. Thanks for watching, and we'll see you in the next case.